Okay, welcome everyone. Thank you so much for joining us for this 2022 case law update with Brian Ohm. I'm first going to introduce Liz Callan, who's going to explain that we are offering the AICP credit and how you can access that after the webinar here. Liz?
Hi, good afternoon, everyone. I'm Liz Callan. I am the Vice President of Professional Development for APA Wisconsin, and I am going to post a link for the event to log it for your CM credits if you are interested in that, if you're an AICP certified planner in the chat.
Thank you, Liz. And my name is Heather Cleveland. I'm the Vice President of Policy and Advocacy with the Wisconsin American Planning Association chapter. And our legislative committee has organized this webinar for today. And Liz is the Vice President of Professional Development. So thank you for your assistance with this, Liz. And Liz will be facilitating questions during the presentation. So if you have a question, please place it in the chat and Liz will help facilitate that. And then also we'll be available after, Brian will be available after the presentation if you have further questions after that. I'm happy to introduce today Brian Ohm. He is a professor, Department of Urban and Regional Planning at the University of Wisconsin-Madison and State Planning Law Specialist at the University of Wisconsin Extension. Brian teaches and has published on a variety of planning topics. He writes a monthly case law update for the APA Wisconsin, and we'll also put a link to that in the chat for everyone to access that. I am happy to have you, Brian, here, and I'll let you take it over. Thank you so much.
Well, thanks, Heather, and thank you all for joining us today. So I'm going to give you I'm just going to give you an annual case law update. I'm not going to really be covering any legislation, but so it's an annual case law update. Lasts about an hour, though I'm able to stay on after to answer additional questions that folks may have. And for many, many years, I did this in cooperation with the local government center in Extension. And given changes in Extension, that hasn't happened for a while. So the last time I did one of these was in early May of 2021. So I'm going to pick up where I left off the last time I did one of these in 2021. So we're going to cover court cases that impact planning from again May 1 of 2001 to pretty much today. And let me just start off by saying there haven't been really any earth-shattering cases over that time period. So it hasn't been any dramatic changes, but there's been a lot of good cases that provide us with some good reminders about a number of different topics. And so we're going to start out, and we'll start with the U.S. Supreme Court and the Supreme Court cases. So there's a handful of cases that occurred over that time, and we're just going to touch on those. And so the first one is the Cedar Point Nurses versus Hassad. So this is a regulatory takings case, and it's not really dealing with a land use or planning regulation, but it still applies with respect to land use and other regulations that may impact property. But this is a case that was dealing with a 1975 California law that allowed labor organizations access to ag employers' property to solicit support for unionization. And the law said, they could go onto the property to try and organize a union, and they were limited to 3 hours per day and 120 days per year. So they were authorized to have access to the employer's property, but it was pretty limited. So by no means a permanent occupation. A number of ag companies sued the state of California, alleging that regulation appropriated an easement for union organizers without compensation and was a per se taking under the Fifth Amendment to the U.S. Constitution. And that applies to the states through the 14th Amendment. And the Supreme Court, it made its way up to the US Supreme Court, and the Supreme Court decided that case. It was a 6-3 decision that in the court, and pretty much the split along the conservative majority and the liberal minority in terms of the decision. The court decided that access requirement did indeed constitute a per se taking of property in violation of the US Constitution. And it's really building off precedent that the courts had established early on, the Loretto versus Manhattan teleprompter case back a number of decades ago, where the court said that the right to exclude others is the most important stick in the bundle of property rights. We all know that, with ownership of property comes a bunch of different rights, and one of those rights is the ability to exclude others. And the court has been pretty protective of that right. And so if you're not able to exclude others from being able to access your property, the court has said that's a per se taking. This was again, a pretty limited right, or the law provided, very limited access. So, again, 3 hours a day for 100, no more than 3 hours a day for 120, at most 120 days. So it was pretty limited. So that was kind of the issue, is whether or not that would be a taking. And the Loretto case from several decades ago that really built this this per se taking was dealing with a requirement that New York City had to require that cable companies could put their cables, back in the days before everything was wireless and you had cable TV and there were actual cables, and the New York City law required that the cables could be placed on apartment buildings, and apartment owner sued, and the court said, yeah, that is a per se taking. So in the per se category, that's a kind of a slam dunk category. That's if they can show that you've been deprived of your right to exclude others, no matter how small, that's a slam dunk taking. There's nothing else that there's really no defense to that. And so the court has really kind of spread that pretty thin here in terms of people being allowed onto someone else's property. The majority opinion does acknowledge, though, that building inspectors and zoning administrators and others may need to access property to enforce laws and make sure that there's nothing criminal going on, and there's no health and safety violations or anything like that. So the court does acknowledge that that those still are probably okay, particularly when it's connected to the receiving of certain benefits, like a conditional use permit, where they're receiving the benefit of being able to do what's allowed in the permit, but then there's some requirement for inspections to go on. So the court does acknowledge that, but it's important to understand that, again, anytime any regulation that allows others access to someone's property is potentially questionable. And again, there's no defense to that. Then there was another takings case. This deals with a kind of a more technical aspect of takings law that applied to what is known as kind of the ripeness context of takings cases in federal court. And this is a challenge to a San Francisco law that tried to deal with condominium conversions, where you're dealing with multifamily buildings, apartment buildings that were organized as tenancy in common, where in theory, under tenancy in common form of ownership, the owners have right to access the entire property. And what the owners would do, what the tenants would do, would contract among themselves to divide the the multifamily into individual residences, and then they would live there. And then some of the people would then convert their interest to a condominium arrangement to allow individual ownership of certain parts of the building. So taking what had been a kind of a rental arrangement and turn it into a condominium, so you have ownership of units. And for many areas of the country that are struggling with affordable housing issues, that change has created some affordability issues. And so a number of communities try and address the condominium conversion aspect, and that's what San Francisco is trying to do. The petitioners sued, the property owners, the unit owners sued, alleging that lifetime lease requirement was an unconstitutional regulatory taking, and that went up through the courts, and it was through the federal courts. It was dismissed as not ripe because of this doctrine that we used to have that court cases aren't going to be ripe in federal court unless they've gone through the state court system. And petitioners appealed that decision, the trial court decision, to the Ninth Circuit Court of Appeals. And while that case was pending, the United States Supreme Court decided the Nick versus Township of Scott case, where they did away with that ripeness requirement, and that now property owners can go directly to federal court and they don't have to first seek compensation through the state court system. And after that decision came down, the Ninth Circuit still affirmed the district court's dismissal of the case, saying that even though that the requirement to proceed through state court was no longer in place, there was still a finality requirement that you can only bring a takings case if there's been a final government decision. And here they said there hadn't been a final decision. You've just got an ordinance that's been placed on the property, and you don't have a final government decision. That made its way up to the United States Supreme Court, and a unanimous Supreme Court disagreed with the Ninth Circuit and remanded the case to district court. And the Supreme Court makes a statement that the finality requirement is relatively modest. So you don't necessarily need a final documented decision. All you need is to show that there's no question about how the government's going to decide. There's no question about how the regulations at issue apply to a particular land and property. And in this case, the court said there was no question that the city's position about requiring the lifetime lease as a condition of conversion of a condominium wasn't in dispute. And so then they remanded this to the lower courts to deal with the takings issue. And again, remember that when we're dealing with the regulatory takings issue, it's where a regulation goes too far. It's as if the government had used its power of eminent domain and it taken the property. And so the remedy for takings is not that the regulation is void. It's just that the government needs to pay compensation. So when the court's remanding these cases, it's sending it back to the lower courts and saying, good luck, figure out how much compensation is due. And this happened decades ago in the Loretto case, and they sent that back to the lower courts, and the level of compensation for having a cable television, a TV cable affixed to an apartment building was determined to be $1. So a lot of these things are being decided purely to establish a legal precedent, not necessarily as things that are going to require a great deal of compensation. So we move from takings to First Amendment issues and the freedom of religion. And in addition to the First Amendment's protection of religion, we also have RLUIPA and the Religious Land Uses and Institutionalized Persons Act. And we have this case that's coming to us from Fillmore County in Minnesota, that county's efforts to try and deal with the Amish who live in the county. And in 2013, the county had adopted an ordinance requiring modern septic systems for the disposal of gray water. So the water used in dishwashing and laundry and things like that. And the Schwarzentuber Amish, a more conservative sect of the Amish, requested an exemption to that requirement because their religion forbids the use of the technology involved with the modern septic systems. The Minnesota Pollution Control Agency filed an enforcement action against the 23 families. The suit alleged in part that the county's ordinance and the requirement for a modern septic system violated the Religious Land Use and Institutionalized Persons Act, or RLUIPA. And under RLUIPA, it states that no government shall impose or implement a land use regulation in a manner that imposes a substantial burden on the religious exercise of a person unless the government demonstrates the imposition of that burden is in furtherance of a compelling governmental interest and is the least restrictive means of furthering that interest. So a pretty high standard for government to meet. And one of the facts of this is the Amish offered to install an alternative system to deal with to deal with gray water that relied on wood chips that would filter the water, and other jurisdictions permitted that technology. The county was unwilling to accept that, and so the county came back and counterclaimed, and they sought an order to displace the Amish from their homes and remove all the possessions, and declaring their homes uninhabitable if they didn't install septic systems. The Amish then sued, and the trial court sided with the county. The Minnesota Court of Appeals affirmed the decision. The Minnesota Supreme Court denied review. This then made its way up to the U.S. Supreme Court, and the U.S. Supreme Court accepted review, and the U.S. Supreme Court said, no, this is wrong, and they vacated the Minnesota court's ruling and remanded the case for proceedings following the Fulton versus Philadelphia case that the court had decided, in which the unanimous court upheld that the Philadelphia had violated the First Amendment's protection for freedom of religion when the city terminated a foster care placement contract with the Catholic Social Services because the Catholic Social Services refused to certify same-sex couples as foster families. And so the court had struck that down as a violation of the First Amendment. And in this case, the argument is that it violated RLUIPA. The court sent it back, and it didn't write an opinion, but Justice Gorsuch wrote a concurring opinion when they sent it back to the lower courts. And he provided some guidance that Minnesota was supposed to follow, and this is guidance that other governments should follow. And in his opinion, he says, courts cannot rely on broadly formulated governmental interests, but must scrutinize the asserted harm of granting specific exemptions to particular religious claimants. And the question in this case is not whether the county has a compelling interest in enforcing its septic system requirements, but whether it has such an interest in denying an exception from that requirement to the Schwarzentuber Amish specifically. And Gorsuch noted that there were other exemptions there for certain classes of uses. And he further states, it is the government's burden to show that this alternative that the Amish wanted to use won't work. And it's not the Amish's burden to show that it will work. So it's the burden's on the government to show that their way is the only way. And it's so as long as the government's able to achieve its interest in a matter that does not burden religion, it must do so. So government's got to try and figure out a way in these types of cases that's not going to impinge on someone's religious rights. Another then First Amendment case that came up is dealing with flagpoles in the city of Boston. And this is the Shurtleff case from 2022, where the city of Boston has 3 flagpoles in front of City Hall. One flagpole, they fly the US flag and POW, MIA flags. Second pole has the state flag, and the third has the city's flag. And the city occasionally flies other flags in place of its own flag. And over the 12-year period, the city had approved 284 different flags to fly and never denied an application. Then they received an application from Camp Constitution, which is a religious organization. They applied to fly a Christian flag, but the city denied the request out of concern that it would violate the Establishment Clause of the First Amendment. So the First Amendment protects the free exercise of religion. So government can't impinge on the exercise of religion, but it also prohibits government from establishing religion. So government's not supposed to be promoting religion. And so that the city said, if we fly this flag, we're promoting religion. We can't do that. And so Camp Constitution sued and said, well, you're violating their First Amendment free speech rights. Forget about this religious stuff. You're violating their free speech right. And the district court found for the city, and the Court of Appeals affirmed, and it makes its way up to the U.S. Supreme Court, and the United States Supreme Court reversed the lower court's decisions and said, you've got to look to the purpose of the flagpole. If the flagpole communicates government speech, then Boston can choose who flies, who's able to fly a flag on their flagpole. And that's not going to violate free speech. Government speech is a different type of speech, and it's not, the government can do what it wants with government speech. But if a flagpole is for citizens to express their views, the free speech clause prevents Boston from refusing flags based on content. And in this case, the court said the purpose is free speech, and that Boston was violating their free speech rights. So the religious organization has the right to fly their flag. The next case we'll jump to was dealing with the First Amendment as well, but dealing with freedom of speech and sign codes. And so it's the City of Austin versus Reagan National Advertising, 2002 Supreme Court case dealing with the City of Austin's sign code that distinguishes off-premises signs from on-premises signs. And the City of Austin has this definition of an off-premise sign that's similar to the definition that's used in the Federal Highway Beautification Act. And the city's code prohibited construction of any new off-premise signs, but allowed existing off-premises signs to continue as long as they didn't change their technology. And that the code permitted the digitization of on-premises signs, but didn't allow for digitization of off-premises signs. So you have this on-premise, off-premise distinction that you find when dealing with commercial signage. And Reagan National sued. They applied for some permits to digitize some of their off-premises billboards, and they were denied the right to do that. And so they sued, saying that that distinction violated the Reed versus Town of Gilbert case, the Supreme Court's big case from 2015, where it essentially said any sign regulation that forces you to read the sign to figure out how to regulate it is a violation of the First Amendment because it's content-based. And so what was unclear from that decision was this on-premise, off-premise sign distinction, because to figure out whether a sign is off-premises, you have to be able to read the sign and say, well, that's dealing with something that's off-premise. And so that was something that was unclear from the Reed versus Town of Gilbert case. This case, addressed that issue, and there was, for those who were thinking that Reed also applied to this on-premise, off-premise distinction, they can rest assured that the U.S. District Court held that type of distinction was not content-based. The Court of Appeals for the Fifth Circuit had disagreed and reversed it, and then the U.S. Supreme Court decided to review the case, but in a decision in 2022, the Supreme Court reversed the Fifth Circuit Court of Appeals and remanded the case for proceedings consistent with the decision. And it said that this distinction between on-premise, off-premise is not content-based. And it doesn't, the problem with the Reed signage was that it was singling out different types of signs based on whether they're political signs, directional signs, et cetera, et cetera. So they're dealing with different subject matter. And they said the way Austin's ordinance is written, it's not dealing with different subject matters. And this on-premise, off-premise distinction is fine, and that it's not a violation of the Reed case. It's content neutral, and so the court it's easier to justify those types of distinctions. So that's what we got for the Supreme Court. We'll just jump quickly then to the Seventh Circuit Court of Appeals in then a related case, and this just came down a few weeks ago. This is a First Amendment sign case dealing with the Adams Outdoor Advertising Company, which is in constant litigation with the city of Madison and Dane County. So there's been a bunch of lawsuits over signage in the Dane County area. And this is dealing then with the city of Madison sign code. So the city's had a sign code for a number of years. In 1989, they had amended the ordinance to try and ban the construction of new billboards. So that's what's generated a lot of litigation. And they also prohibit digital displays. That was added in 2009. The definition of advertising sign was amended to try and address Reed. And so you see the current definition that's in the ordinance there at the bottom. And as this case was pending, it Adams Outdoor sued, and it went up to the district court. The district court held for the city, and then it went to the Seventh Circuit Court of Appeals, and the city of Austin case was pending. So the Seventh Circuit delayed deciding the case until the U.S. Supreme Court decided the Austin case. And then in the past January, following the U.S. Supreme Court's decision in Austin, the Seventh Circuit then rendered its decision and found that the city of Madison's off-premise, off-premise distinction was not content-based, so strict scrutiny doesn't apply. So strict scrutiny is a very high standard to meet. It's almost impossible to meet that standard to justify a sign. The court does give us some nice language in terms of, strict scrutiny doesn't apply, but intermediate scrutiny applies, and it gives us some guidance here in terms of understanding what's this intermediate level of scrutiny. And the government has to have a substantial governmental interest. The court in the case says, billboards by their very nature can be perceived as an aesthetic harm, and the city doesn't have to approve its aesthetic judgments are right. So just saying that things are being done for aesthetic purposes is fine. And also there is a connection between billboards and traffic safety. And again, the court says, it doesn't take a double-blinded empirical study or near linear regression analysis to know that the presence of overhead signs and banners is bound to cause some drivers to slow down in order to read the sign before passing it. So it's, these types of ordinances will still be challenged, but it's pretty easy for government to justify those types of ordinances. We're now going to jump to the U.S. Supreme Court as we make our way down. We're going to Wisconsin Supreme Court. Sorry, we're going to move to the Wisconsin Supreme Court as we make our way down. So there were a number of Wisconsin Supreme Court cases that are of interest, and the first case we're going to deal with is the City of Mayville versus the Department of Administration, 2001 Wisconsin Supreme Court case dealing with the cooperative boundary agreement that was enacted between the village of Kokoshki and the town of Williamstown in Dodge County. So they entered into a cooperative boundary agreement plan in which the the village was going to attach all the town territory. And so the town of Williamstown was going to go out of existence, and they were going to rename Kokoshki to the village of Williamstown. And then there was also, they were going to create a detachment area adjacent to the city of Mayville, because the town of Williamstown also totally surrounds the village of Mayville. So you've got this agreement going on between the village and the town that doesn't include the city of Mayville, but Mayville is certainly going to be impacted by what's going on. The Wisconsin DOA, the Department of Administration, approved that plan. The village of Mayville sued, and the circuit court reversed the DOA's approval of that plan, finding that the cooperative boundary agreement statute does not allow a cooperative plan to be used to absorb an entire township into a village, as was done there. So that was kind of the issue the circuit court focused on. That was appealed to the Court of Appeals. The Court of Appeals didn't address that issue, but said the DOA erred in approving the plan because the plan did not include the city of Mayville as a party. And the court cites the section of the cooperative boundary agreement statute that says that that no boundary can be changed unless the municipality is a party to the cooperative plan that changes the boundary. And the cooperative plan had created this detachment area which would change Mayville's boundary, but Mayville wasn't part of the plan. So, you know, again, that's why Mayville sued, and the Court of Appeals said, yeah, Mayville, you're right, you should have been party to that plan, and this cooperative boundary agreement is no good. That went up to the Wisconsin Supreme Court. The Wisconsin Supreme Court accepted the petition for review. They reviewed it and they agreed with the Court of Appeals decision that Mayville should have been a party to the plan, and the plan is not valid. But again, neither the Court of Appeals decision nor the Supreme Court's decision addressed this issue of whether the cooperative boundary agreement planning process can be used to absorb an entire town into a village. That's still kind of a question to be answered. I did email Eric Schmidtke, who many of you may know. Eric's a former student of mine, but he's the head of boundary review for DOA and is the body that approves the cooperative boundary agreements. And I just wanted to find out what the status of things were. Oops, sorry about that. Yep. There we go. Here we are. And he said because while the case was pending, the village and the town had consolidated, so they were already operating as one. And when the court said you can no longer do that, that left the town scrambling to figure out, okay, how do we govern ourselves? And so they were kind of left scrambling. And according to Eric, what quickly happened then, the town and the village of Kokoshki used the other process, used the general agreement process to lay out the framework for consolidating the two communities, and then use that process to attach the entire town to the village of Kokoshki. So there, as we speak, there is no town of Williamstown anymore, but the village of Kokoshki is now encompasses all of what had been the town plus the village, what had been the village. So that's all one now. According to Eric, the city of Mayville has also sued on that. So again, we may see this case go back to the Wisconsin Supreme Court for resolution and to try and figure that out. So it's kind of an ongoing battle, kind of an interesting thing. The next two cases I'm going to quickly deal with are cases that came down together on the same day, in 2021, by the Wisconsin Supreme Court, kind of dealing with this different aspects that that revolve around DNR's authority to do certain things, and oops, there we are. So the first case is the dealing with high capacity wells, and so DNR is responsible for evaluating applications to high capacity wells, and there's an environmental process involved for reviewing applications that DNR's follows, and while the process is not required, DNR sometimes will consider the effects. And you have there were 8 applications that fell into this category where DNR didn't consider the potential effects, but DNR did have information that the well would negatively impact, the wells would negatively impact the environment. But despite that knowledge, DNR approved the applications. And then Clean Wisconsin and the Pleasant Lake Management District appealed the decision through the administrative appeal process, and then to the circuit court, and they said it was that DNR's actions were contrary to the Lake Beulah case that the Wisconsin Supreme Court had decided in 2011. In that case, they held that DNR had broad authority to consider the environmental impacts of high capacity wells. And DNR said, well, yeah, but after that case, the legislature enacted section 227.10 of the statutes that limits the DNR's authority to only those things that are explicitly required or explicitly permitted in the statutes or by rule that the legislature has approved. So the legislature is trying to curtail DNR's authority. And so the DNR said, we don't have authority to do this. The Supreme Court held 4-2 that nope, DNR erroneously interpreted that section of the statute, and DNR does have the authority to consider the environmental effects on these wells. And so they said that statute didn't alter the court's analysis in the Lake Beulah case. So the legislature gives general authority to DNR to review these things, and the court's saying, that meets the definition of explicitly, that more general authority. So the court then remanded that case. The companion case that came down the same day, also brought by Clean Wisconsin against the DNR, dealt with a CAFO, the Kinnard Farms operation in Kewaunee County, and they wanted to expand their dairy operation, and they applied to the DNR for the issuance of the NPDES permit that's required for those operations. And DNR reissued the permit. The neighboring landowners sued, and saying that expansion would exacerbate all sorts of groundwater contamination issues that are going on, and they challenged it through the contested case process. The hearing examiner ruled that in favor of the property owner, saying that DNR needed to impose those conditions to require monitoring and set a limit on the number of animal units. The DNR then went to the Department of Justice and sought an opinion about DNR's authority, and the Department of Justice said, the DNR does not have that authority. So the DNR secretary, issued an order reversing the ALJ's decision. The neighbors appealed to the courts, goes through the court system, makes its way up to the Wisconsin Supreme Court, and the Wisconsin Supreme Court again held 4-2 that the DNR, yes, has that authority to impose those requirements for an animal unit maximum and to monitor groundwater conditions. And that authority wasn't taken away by that statute that the legislature had. So the court's very supportive of a broad delegation of authority to DNR. The last Wisconsin Supreme Court case I'm going to deal with is the Nudo Holdings versus the Board of Review for the city of Kenosha. This is a case actually challenging the assessor's valuation of the property as residential. They were arguing that this should be agricultural use under the use value assessment law. We're seeing more of these types of challenges because use value assessment gives a significantly lower taxes for ag land as opposed to other uses. So you've got a property owner here who's arguing, a developer who's arguing it should be assessed as ag land, and the city's saying no, it's we think it's residential, and the standard that this needs to be evaluated against is the substantial evidence standard, and so I'm just going to focus more on the substantial evidence standard because that's also come up a lot. It's created a lot of confusion, I think, in the conditional use permit process following Act 67, where local governments, the substantial evidence standards explicitly applies to issuance of conditional use permits, and I just like this the court's statements in the last two bullets there about the substantial evidence. The court says, the Wisconsin Supreme Court says, substantial evidence is perhaps misnamed in view of modern parlance. It is not a high bar. Substantial evidence is evidence that reasonable persons could reach the same decision as the board. So it's even though we use the term substantial, it doesn't mean a high standard. It's just some evidence, and the court also says, we're highly deferential to the board's decision. And this is a case where the property owner said, well, I've got some walnut trees growing on my property and some Christmas trees, so it's an ag use. And the assessors say, no, there's no ag use that's going on here. And so the court says, that's fine. That meets the substantial evidence standard. The city's determination that that's not agricultural use. So we're going to then move on to the Wisconsin Court of Appeals. And we've got a few cases that we'll deal with that came up by the Court of Appeals. And the first case I want to highlight is the Nordstrom case versus Kane. And there have been more and more cases that have popped up dealing with restrictive covenants. And this popped up as a big issue recently, and some issues that were going on in the city of Madison, and the impact of a transit-oriented overlay district in the zoning ordinance, and how that is affected by deed restrictions that are in some of the covenants that are impacted in the overview. So there's a lot of confusion and about restrictive and covenants, and it's coming up all the time. And this is a case that's just kind of interesting about the interplay between local governments and restrictive covenants. So again, restrictive covenants are private agreements in terms of what can be done with the use of property. And so you've got one property. So you got restrictive covenants. You often have one property owner suing another property owner about some confusion or some concern over whether or not someone's violating the restrictive covenants. And so you've got here a property owner owns 7.44 acres in the town of Gibraltar in Door County, and there's restrictive covenants on the parcel that says the parcel can contain 3 dwelling houses and 1 additional dwelling house and such accessory buildings as may be permitted by the Door County zoning ordinance may be constructed, erected, placed, or permitted on said tract. And then it states tract 54 may not be divided so as to create any additional tracts therefrom. And the Kane proposed creating a condominium with 3 detached single-family residences on this parcel on tract 54, and they was going to then sell 2 of the units and use the 3rd to build a single-family residence. And Door County approved the condominium plat. So the condominiums are often confusing because the condominium is a form of ownership. It is not a form of building type. So, we build, multifamily apartment looking like buildings that are built as condominiums. So there's that. But then we can also do single family residential detached developments as condominiums where the land is not subdivided. The land is held in common, and then each individual house is built on a unit and have a unit where the house is built. And that's what the Canes are proposing to do. Door County approved that. The neighbors didn't like that, and so they sued, alleging that the condominium subdivision violated the restrictive covenants. And the covenant said, the parcel can't be divided, and this condominium plat was dividing it, and the Cane countered that, well, no, condominium subdivisions don't divide land like a subdivision or land division. They're not creating additional tracts. Circuit Court agreed, and then it went up to the Court of Appeals, and the Court of Appeals affirmed the lower court's decision that that this is in fact a violation of the restrictive covenants. That even though the restrictive covenants don't define what is meant by divided or tract, the court looks at Webster's dictionary to define the terms, and according to Webster's, divide means to separate into two or more parts, areas, groups, split up, and tract is defined as a precisely defined or definable area of land. And the court says, well, the condominium plat is separating the parcel into two or more precisely defined areas of land. And it's dividing the land, even though it's not a subdivision in that context, or land division in the conventional context. And so the court says, yes, that violates the terms of the restrictive covenants. And the court also noted that for application of the county zoning ordinance, they would be considered a separate lot of record under the county's zoning ordinance. But here again, even though this was okay under the county ordinances, it was in violation of the restrictive covenants, and so prohibited through that manner. The next case we're going to deal with is a regulatory takings case, kind of interesting case coming to us from the city of Brookfield, 2022 case. And you've got the Facet, who owns a 4.93 acre of land that's located between two subdivisions in the city, and each subdivision has a dead-end street named Choctaw Trail. It terminates near the middle of the Fawcett property, and Fawcett proposed to split her land into 3 single-family home sites, and with 1 lot with wetlands that would be dedicated to the city. Went to the city with 3 different concept plans. One was to create a cul-de-sac connected to the eastern portion of the Choctaw Trail, but leaving a dead end on the western end. Second alternative was to connect both dead ends with a through street that would cross the Fawcett property. And the third was to use a shared driveway for the 2 lots that's coming from the east. So again, you've got the Fawcett property is in between 2 subdivisions. There's a 2 roads that dead end at the Fawcett property. Now that she wants to develop this, and the city wants option 2 to connect the 2 dead ends. And Fawcett, however, doesn't want that and wants to use the shared driveway approach and still leaving the streets as dead ends. And Fawcett submitted a certified survey map creating the lots without the connected road. City rejected the application. Fawcett sued for an unconstitutional taking. The circuit court held that the required land dedication for the connecting street and the street connection as conditions of approval were regulatory takings under the U.S. and Wisconsin constitutions. The city appealed to the Court of Appeals. The Court of Appeals agreed with the circuit court, and the city's requirement that Fawcett dedicate part of her land for the roadway and to pay for the construction of the new street was an unconstitutional taking. So this is dealing with the kind of the unconstitutional conditions part of the takings equation. And so that brings to light the Nolan-Dolan two-part test, where government must establish under Nolan, the government has to establish an essential nexus between the government's interest and the exaction, the condition that their government's trying to achieve, and the government must demonstrate rough proportionality between the exaction and the impact caused by the development. And here, the court said, well, the city failed to meet its burden to show that the street would mitigate the adverse negative impacts caused by the proposed land division. The condition is trying to deal with the dead end streets, but the existing street problem was not created by the Fawcett's proposed land division, but was created by the earlier plats that abutted the Fawcett property. And so the court says the elimination of this pre-existing defect does not establish a constitutional basis to then require that the Fawcett bear the entire burden of and all the costs of putting into place this public street to benefit the public at large. So that constitutes a taking. So if the city wants to do that, they're going to have to pay compensation to the Fawcett's and acquire the public right of way that way and pay for and the city has to pay for the street, because that's not something that Fawcett has caused and it doesn't meet the Nolan-Dolan test. So interesting case. The next case we have is the Waupaca, coming to us from Waupaca County and dealing with shoreline zoning and the overlap between shoreline zoning and general zoning. So you've got an individual who owns residential property on a lake in the town of Dayton in Waupaca County, and the property owner contacts the county about building a second-story addition to their residence, and the county tells the property owner that they need a land use permit and there's a side yard setback that's they're going to need to get a variance for the addition. And Gola said, well, thanks. And then they went to the town and got a building permit. The town says, well, be sure to talk to the county. But Gola property owner never went back and talked to the county and never applied for a permit or variance, and just they did contact their state legislature, who told them that no county permit was necessary. So they went ahead and constructed their addition. The county sends them a letter, a cease and desist letter, but the addition's completed. The county then cites the property owner for failure to obtain a land use permit and a variance. And it goes to circuit court. The circuit court determines that the property owner did in fact violate the county zoning ordinance requirements and orders property owner to remove the addition. They then appeal to the circuit court. They appeal the circuit court's decision to the Court of Appeals, and making the argument that state law prohibits the county from regulating the addition under the county's general zoning ordinance. And in the shoreline zoning law, it has this statement that county shoreline zoning ordinances may not regulate a matter more restrictively than the matter is regulated by the state law zoning standards that are in state law. And so, the shoreline zoning ordinance establishes one size fit all standard that counties can't be more restrictive than, but counties can regulate matters that aren't regulated by those state standards. And so the debate is about whether the general zoning ordinance that deals with other things applies. And the Court of Appeals disagreed with the Court of Appeals disagreed with the property owner and in terms of their interpretation, and the court says there's no state shoreline zoning standards for side yard setbacks or land use permits. So those are things that aren't dealt with in shoreline zoning law. And again, the court notes that the shoreline zoning law, again, only prohibits counties from regulating matters more strictly than those state standards. And it doesn't nullify all general zoning ordinance provisions, even though they may apply within the shoreline areas. And in this case, the court says, well, the general zoning ordinance provisions apply to any property in a sewered residential district. And the Gullah property was in a sewered residential zoning district. So it had nothing to do with shoreline zoning. It's just that they're in a sewered residential zoning district. And so they had to comply with the standards that apply to all residential development in sewered areas in the county. And so they need to get a land use permit, and then they would also need to apply for a variance, and that's none of that stuff's connected to the state shoreline zoning ordinance. So the Court of Appeals, disagreed with the property owner's contention, but agreed with the circuit court that this addition was not permitted and violated county ordinances, and so they had to essentially tear it down. Just to note that the Supreme Court, Wisconsin Supreme Court, has granted review of that decision, so stay tuned. We'll see what the Supreme Court does with that. The last case we're going to deal with is deals with the CAFO and CAFO expansion and the town of Ledgeview in Brown County, and it's dealing with a permit. So the state has taken over a lot of the permitting for large-scale livestock operations under the livestock facility siting law. So there's state standards that need to be followed, and local communities can't really do much beyond those standards. There are some conditions that they can do, but they can still review permit applications for expansions, which is what Ledgeville is doing. And the town denies the permit because there's a history of past violations, and so they don't think that the facility is going to be able to meet state standards, and so there's concern there because of these past violations. I think those violations are just going to continue, and also they're concerned about the refusal of the town to be able to inspect the premises, and the Ledgeview Farms says no, you can't inspect. And under the livestock facility siting law, that denial was appealed to the livestock facility review board, and the review boards found that those claims by the town were valid. The concerns were valid, so they upheld the denial of the permit. That then goes to the court system and makes its way to the Court of Appeals, and so the circuit court affirmed the board's decision, and the farm appealed to the Court of Appeals, makes its way to the Court of Appeals. The Court of Appeals affirmed the board's decision and says, there's clear and convincing documentation in the record from which the board can conclude that the application was not credible as to the farm's commitments to comply with state runoff management standards. So again, that's just go back. That's this issue will come up in other contexts in terms of whether or not a party, an applicant that has some bad history, and whether or not that's something that can be considered. And this certainly supports bringing that bad history into consideration when reviewing permits. So with that, that's all I've got. I've got 1 minute for questions.
Okay, thank you so much, Brian. And apologies to everyone that we discovered a 100 participant capacity. We'll correct that for the future, and please let your colleagues know that we are recording this, and we'll send that out. And Liz has changed the AICP credits to be an on-demand option. So we will work on that for the future. So just want to let everyone know that we did discover that today during this presentation. I'm just going to go in order of the questions that were asked along with the cases, Brian. So okay. This first one, if you don't mind going back to the slide, it's slide 3. So this is from David Buck. Question: in relation to the access case, Cedar Point versus Hasid, would it be legal if the access requirement is part of the planned development or conditional special use permit where the landowner applies for consideration of uses, dimensional regulations, density, et cetera, that are outside regular code requirements, such as allowing a lot without public right-of-way frontage?
Yeah, I think it is. You know, the court does, you know, again, acknowledge that that, you know, when it's done as part of a you know, a granting of benefit. So, you know, whenever any type of, you know, no one has a right to, you know, to a conditional use permit, or no one has a right to rezoning or plan development. Those are all kind of a condition, or subject to condition. So they're receiving the benefit of being able to do what's allowed. And so I think requiring access to inspect things and to do the things that you mentioned should be something that falls within this acknowledgement, this acknowledgement by the court that this is it's okay to have access for those purposes, because, you know, government has a legitimate purpose for doing that. So I think it should be okay.
Okay, thank you. I'm going to move on to the next questions. And this does conclude the webinar. So anyone who wants to stay, please stay, but the questions and answers will be a part of the recording should you want to check that out in the future. Okay, the next, I'm going to say two questions, and this pertains to slide 35. It comes from Mark and Sam. I'll read them both one after the other. It's about the same case. So in the Nordstrom case, did the court find that the county was wrong to approve the development, or just that the owner had no right to ask for county approval under the covenants? And then the second question, did Nordstrom versus Kane decision suggest municipality somehow acted inappropriately by approving the plot, or was this a purely private course of action between the two private property owners with a private non-governmental remedy?
Yeah, so this is purely, so both. This is there's nothing wrong. The county did nothing wrong, and there's nothing, and the county is not a party to this at all. This is purely a dispute between two private individuals, and so you know, for many, you know, it gets really confusing, I think, to the property owners, because they kind of you know, and I've seen this happen elsewhere in the state where you know, property owners, you know, kind of confuse zoning with deed restrictions, and you know, they really don't know who enforces what, but you know, they're both kind of regulations that apply to their property, and some local governments are better about others about kind of recognizing that there are these private restrictions, and so they'll tell the property owners, well, you know, be sure to check the you know, the deed restrictions that are on the property, because even though we say you can do this under the local government's ordinances, there might be other things that say you can't do it. So there's nothing wrong that the county did, and so this is again purely a dispute between two private individuals, and just again the conflict that can arise where the county ordinance is saying it's okay to do one thing, but then the restrictive covenants, you know, say something completely different. So there's nothing in state law that requires, you know, that gives zoning the right to override deed restrictions, or force deed restrictions to somehow be consistent with zoning and other things. So they can again be going in opposite directions. That's just the way the system is.
Okay, thank you. The next question pertains to slide 40. This is from Carrie. Would appearance on the city's official map connecting the two dead ends make any difference in the Fawcett case?
Yes. Yes, I don't know, maybe there's someone from the city of Brookfield, who knows, but so I don't know if if there was an official map involved in this at all, but you know, the official mapping law allows for a community, if an area is officially mapped, the local government can then say no to someone who comes in for a building permit that wants to build in the area that's been officially mapped for a you know, a road or a park or whatever it's been officially mapped for, and that's not going to be, and that won't be held to be a taking. So because no one has a, you know, there's no guarantee, there's no right to being able to get a permit, you know, and so having an official map would be would have perhaps resulted in a different outcome, because you know, more from the city standpoint, the city would have been able to say, well, you can't, you've got to design it, you've got to pick, you got to pick the option. You've got, well, where's the option? You've got to pick option 2, right? Oh dear. Where'd it go? Yeah, we've got to pick. You've got to pick. You know, if this had been in the official map, it's got to be a through street. Then the city would have said, well, you know, you do something else, we're not going to give you a building permit unless they drew the lots to be outside the area that was officially mapped. So an official map could have resulted in a different outcome.
Okay, thank you. Does anyone else have any other questions? Feel free to speak and ask Brian.
Let me just say that there are many, you know, official mapping law is probably the least used of our planning tools. You know, not everyone has zoning, not everyone has subdivision regulations, but very, you know, relatively very few communities have official maps as prescribed in state law, you know, following the requirements of state law. So it's another tool in the toolbox.
Okay, great. Well, I'll say thank you so much, Brian, for your presentation. Thank you, everybody, for attending. And I will send out a PDF of the PowerPoint along with this recording. And we really appreciate it. I'm going to go ahead and stop the recording now.